Thanks for joining us. Here's part one of the Wills and Trust seminar by Sam Kreamer to a group of educators considering retirement.
Well, first of all, thank you very much for letting me come and speak to you guys today. I have a great connection with teachers. My wife is a special ed teacher at Hubble School here in town, and her special ed background allows her to be very patient with me, which I truly appreciate. In addition, my mother, Rhoda Kreamer, actually worked with Don Brubaker, and she wrote the first Head Start grant for this area. In addition to that, my grandfather was a teacher in New York City and realized that's no place to be a teacher, and came to Des Moines, and my father was both a physician and a teacher at what was then the College of Osteopathic Medicine. Me, I'm a product of the Des Moines schools, and I would tell you that several of my teachers were very pleased to find out that I graduated and did not have to do time in prison. My goal today is to speak about estate planning, and basically, I'm aware that what I'm trying to do is just kind of give you an overview. I'm not trying to make you guys into geniuses about estate planning or lawyers. But the most important thing is to make sure that I answer your questions. So if you guys have some questions before I start what is my quasi-prepared presentation, I'd be happy to put them on the board and make sure that I answer them. Do we have particular topics you want me to hit? My goal in today's presentation is to talk about wills, to talk about powers of attorney for healthcare, to talk about powers of attorney for financial matters, and to a certain extent I'll talk about trusts, but the mind can only absorb what the bottom can endure, and so we've got just this hour that I can present. There's a wonderful benefit of having been in practice for 36 years. And the benefit is you see a lot of stuff, okay? And I was told a story about this fellow who taught in the schools, and he just really wasn't feeling very good. And his name, we'll call him Mike. He was not feeling very good. And his wife, Sally, who was an accountant, we'll call her Sally, just decided, it's time, before the legislator steals all of your health care benefits, to go see a doctor. So they go see a doctor, and the doctor checks him, and it's up and it's down, and EKGs and MRIs and blood tests and work and stuff. And doctor says, Mike, I want you to go get dressed. I'm going to talk to Sally. And Sally says, well, what has he got? Sally, what he's got is failure to thrive. You got to take good care of him because this could be a terminal condition. She says, what do I have to do? She says, you got to let him watch whatever he wants to watch on TV. You got to feed him whatever he wants to eat, and you got to give him good loving and take good care of him because this is a critical, possibly terminal condition. Sally says, I understand. They're back in the car. Mike says, well, what do you say? Sally says, Mike, you're going to die. Well, that's certainly one form of estate planning, right? I mean, Sally has already decided that Mike be going to die. Estate planning is not about you're going to die. Estate planning is you taking control of what happens if and when you can't make decisions about them yourself. That's fundamentally what estate planning is. It's taking control. It's for you to be able to guide your own path. One of the questions is a little bit like the Susie Orman question. Do you have to be rich? No. The thing that you have to be is caring. Estate planning documents take effect when you can't make a decision. For instance, if you can't make a healthcare decision for yourself, you have to care enough to appoint somebody to make those decisions. When you pass, you appoint someone to make sure the assets are distributed the way you want them. Estate planning oftentimes focuses on wills, and I'm going to make the bulk of my comments about wills. But really, arguably, the most important are those powers of attorney for healthcare. It's who makes healthcare decisions for you. But although I'll spend the least time on them, arguably, they're the most important. Well, who's involved in this estate planning? Well, certainly you can get a lawyer in the box, you know, those legal Zooms or other types of prepackaged estate plans. But the most important player in estate planning is you. And the reason you're the most important is because it's a question of what do you want to have happen. And if you're not engaged, or if your lawyer is not engaging you, you got to make a change, because you are the single most important player. Now, arguably a lawyer is important, arguably a insurance professional is important, arguably a banker is important, but I have seen cases where a family counselor is important. One of the questions that is often asked in our practice is, should I give a copy to the kids? We say no. And the reason we say no is because things change. And we have found that sometimes when young people get a copy of the will, they want to split up your assets before you're even sick. So one of the things we talk about is to have confidentiality. Maybe you want them to have a copy of the will. Maybe you don't. Okay, I'm going to start off talking about why a will is so important. A will ultimately is what is used to distribute your assets, but it's also what's used to appoint a guardian for minor children. Does anybody in this room have minor children? Yeah, me neither. Actually, my daughter has had a daughter, so I'd be a grandpa. However, this is something you should talk about to your adult children, okay? A will is one of the primary ways someone appoints a guardian for a minor child. A will can protect a spouse, but more importantly, a will can also protect grandchildren. And the way it protects grandchildren is oftentimes, as I'm going to discuss, wills create trusts for young people. Certainly it's possible that your children or your child can pass before you, right? And you would arguably want your grandchildren, the children of your children, to get their share. A young person getting a bunch of money at a young age can be a really bad thing, okay? And one of the ways to protect against that is to have a provision in the will for a trust for grandchildren. Well, so who are some of the players in a will? Well, the first player is the executor. The executor is the one that stands in your shoes, okay? And the executor is the one that creates an inventory. The executor notifies creditors. The executor is the one that's the key person, okay? Executor could be anybody. It could be a spouse, it could be a child, it could be a bank, okay? What you want is somebody who would be able to make economic decisions for a reasonable period of time. Guardians, because no one in the room has a minor child, you won't be appointing guardians for your adult children, although I've got this one child that could use. The point is, that's something that you should talk about to your children. But the thing you should know about distributions is, as with many things, there are two ways to do them. You can distribute outright. You know, I give $10,000 to Marcy, okay? Outright distribution. And the other is you can distribute in trust. I'm going to talk a little bit about how trusts fit in with a will and an estate plan. But with a trust, you need to name a trustee and determine distributions. Okay. That's what a will is. Now, when someone dies, okay, so I had this couple come in, and we're doing an estate plan consultation and talk about, and I said, and when you die, this woman starts to cry, and she says, I'm not even sick. So in our office, nobody dies. People pass. Life insurance blooms. I mean, we use whatever euphemism that we can think of, because no one wants to think about death. And again, estate planning is not about death. Estate planning is you taking control of what happens when you're not available to make a decision. That's what estate planning is about. Okay, so the first thing that you should do when someone passes is grieve. Lawyers can wait. Money can wait. Children can wait. Everything can wait. When there is a loss in the family, the most important thing is to do that which you need to do to make sure you are whole again. First, take the time. Everything else will wait. Second, find the will. The oldest will that I've actually admitted to a court is 47 years old. Okay, the will was 47, not the deceased. So just because it's old, it doesn't mean it. Gee, it's a lot like people. Just because they're old doesn't mean they're wrong, right? And that it was still admitted and was still followed. And the problem with that will, and it was a minor problem, is a lot of the people that were supposed to get bequests were already gone. An old will not necessarily reflect current considerations. After you get the will is presented to the court.
I have a real quick question here.
Sure.
My mom just updated her will.
Good.
And she signed it, put it in a lockbox, and then gave me a copy that's not signed. And she said that she was advised by her lawyer to not sign the copy that I have. Is that a good idea?
That is a common practice in the law. The reason for that is there should really only be one signed copy, because at least at this point, although we're using electronic filing, the only copy that's admissible to probate is the original signed witnessed copy. So if there's copies with signatures floating around, not such a good thing. There are some provisions in the law where you can, in extremis, cause a copy of a will to be admitted. Unsigned copies cannot, however. And the reason for that is there is no showing at all that it was ever effectuated. And again, the will is designed to reflect the wishes of the testator. If it's not signed, can't. But the answer is there should be one signed and it should be kept in a safe place. What we do for our clients is we hold the original copies in off-site storage in this temperature-controlled room where if there's ever a problem, it's dust comes down. They've got a powder rather than water. So the question of where should you keep the will? You should keep the will where it not only can be found, but also you should only keep the original there. Now, what we do with our clients is we provide notebooks with copies of all this stuff, okay? And we have a big thing in the notebook that we give our clients that says, Sam's got the will, okay? So that way there's a way to find us. And the Bar Association now says, if Sam's gone, here's who's got the will. So there are ways to lay your hands on the will. Once the will is found, the probate process starts. Now, one of the questions that people have is, how can I avoid probate? Well, probate is the court-supervised distribution of the assets in accordance with your will. The real alternative to probate is to create a revocable trust, and again, because of time constraints, I'm not going to talk too much about those, but really what they are is a supervised distribution of your assets. The trustee of a revocable trust basically steps in, and it's the trustee of that trust that does all the things that are necessary to be done. The downside of that is no court supervision, and the further downside is that you don't get a good reading on the creditors normally, okay? Revocable trusts are more expensive to create. We certainly charge more. But the real issue on revocable trusts is they don't get funded. A revocable trust only works to the extent assets are in the revocable trust at the time you pass. If you don't put all your assets in during your lifetime, you've got to have a will that puts them in the revocable trust, so you got to probate anyway. Okay, we find that oftentimes these revocable trusts aren't effectuated. Accordingly, we're not big on them. What we're big on is making sure that what you want done gets done, and the easiest way to do that's in a will. Now, people get concerned about probate fees. In Iowa, the probate fee maximum is a massive 2%. I would tell you that this is a bigger problem on the coast, but interestingly enough, in revocable trusts, there is no maximum fee, okay? So it's whatever you can get. Well, it's not such a good thing sometimes. Because things have to be in the trust to avoid probate, and then distributed upon the passing, we feel like there's kind of a two-probate system, right? You start by sticking it all in the trust, and then you got to pull it all. We are just not big on revocable trusts, with this caveat.
Click ahead to Part 2 of the Kreamer Law Firm Wills and Trust presentation by Sam Kreamer.